Okay. I see the court is complete. Good morning, Judge Max. Good morning, Judge Hoff. But why don't I see Judge Hoff anymore? Oh, yes, Judge Hoff. Judge Smart, Judge Hoff, do you hear me? Judge Hoff, Judge Smart, you are muted. Yeah, okay. You are unmuted now. Judge Smart?
Yes, I can hear you.
And Judge Smart? I think Judge Smart is muted. He's trying to connect. I see.
JP, can I call the case now?
Yeah, I don't see Judge Smart yet. I want confirmation.
Okay.
Then, yeah, there is Judge Smart. You can call the case now.
Okay. Case number SA70 of 2018. The Minister of Agriculture, Water and Forestry and 8 others versus Amon Ngavetene and 5 others.
As the court pleases, my lords, I appear on behalf of all the appellants. The first appellant instructions from the government attorney and the second to ninth from Engling Stritter and Partners.
Thank you very much. So if we speak, we unmute. If we finish speaking, we mute so that we don't have an echo. If it's fine with the judges, Mr. Barnard, you can proceed to address us.
Thank you, my lord. My lords, there are 6 grounds of appeal raised originally by the first appellant and also relied upon by the second to ninth appellants. If I may, I wish to start with the 6th ground of appeal, which is dealt with in my heads of argument from paragraph 33 on page 9.
Please proceed, counsel.
Thank you, my lord.
There is a problem. No, you don't need to pause. Just proceed.
Thank you. The 6th ground of appeal is against the order setting aside the appointment of the directors. At the outset, I must point out that this issue was not raised on the papers in the application. It was, however, raised in argument with reliance upon the Chico Octagon judgment. The point made was if the directors of the 9th appellant, Mitko, had acted as such for an extended period and the appointment is then set aside, the 9th respondent would be left without directors for an extended period, with the result that everything these so-called directors did is void. And the consequences of that, although not addressed in the papers, I submit are obvious. And for that reason, with reliance on the Namibia Airports and Fire Tech judgment, it is submitted that the Porta Quo should have dealt with this and considered what the consequences of the setting aside of the appointment would be, all the purported actions by these directors amounting to nullities. That was not done. I further submit that in the circumstances of this matter, irrespective of the complaints aimed at the actions of the minister, the first appellant, the consequences of the setting aside on the ninth respondent and third parties having dealt with the board of the ninth respondent could be far-reaching. And for that reason, although a declaration of invalidity of the appointment was competent, the default order should not have followed, and the court should have declined to set aside the appointment. And if this, I submit, if this sixth ground of appeal is upheld, I need not deal with the other 5 grounds of appeal, my lords.
But aren't you accepting that the appointments are invalid if you only base your appeal on this ground?
My lords, the problem I have is with the second ground of appeal, the functus officio finding of the court of quo, because it is so that on the date that the first appellant, the minister, appointed the directors, the second to 8th respondents, his concession that the previous appointment had been done unlawfully had not yet been made an order of court, and that appointment had not yet been set aside. So in effect, there were still directors appointed in terms of the wrongly appointed in terms of the Public Enterprises Governance Act, which was not applicable. And he couldn't appoint further directors until the appointment of those directors, the invalidity thereof, had been sanctioned by court. And I submit it's a timing problem, and it is really such a formal mistake. It is not a case of the minister ignoring other decisions of the minister, having disregard to the public law. I submitted this was a case of the minister actually acting expeditiously, in fact, too fast for the legal process. He assumed that once he had conceded the invalidity, it would be made an order of court forthwith. And there his mistake lies. Technically, he was functus officio. But I submit that mistake.
You're conceding it was an invalidity then?
Yes.
Isn't that the consequence of that? Whatever his motives were, and I accept he had good motives for trying to rectify a position, but do you accept there was an invalidity as a consequence of functus officio being breached?
Yes, my lord, I do. I concede that.
I see. Well, then your other grounds of appeal fall away.
Yes, my lord. Except for the 6th, my lord.
But why didn't you raise it? Why wasn't there a factual basis raised in respect of this issue? Surely it's an issue that should be addressed on the papers,
yes,
and not left to a court to speculate about. What about the doctrine of ratification? Your opponents may have wanted to address how ratification could be applied and could address any invalidity of the actions of the board.
My lord, I submit it is unfortunate that it wasn't raised on the papers. But I submit, my lord, it follows that where a corporation such as the 9th appellant, Meetco, acts for 21 months and all those actions are invalid, the consequences are severe. They are the board of directors is the body that governs the 9th appellant. And if everything they did in this period is void, the consequences are too ghastly to contemplate.
Well, can't they be ratified?
No, my lord, I submit not. If an action is void, it cannot be ratified. Ratification renders lack of authority or remedies a lack of authority, but ratification cannot remedy a lack of capacity. Once there were no directors, there couldn't have been contracts concluded, there couldn't have been actions by them on behalf of the ninth appellant. The position here is, I submit, not similar to the position of a company, but rather should be equated to the position of a trust, where the number of directors fall below the minimum required, and anything done by the remaining trustees, I beg your pardon, is an invalidity. It has no effect. And where, for instance, a pension fund has a constitution, and it prescribes certain actions to be taken and the manner in which they be taken. Outside of the constitution, any actions have no legal validity. And although I did not address this in the heads of argument, there are authorities to this effect, which I did find. I submit a good summary of this position is in the judgment of the Western Cape High Court in 2012. It's Meyer, MEIJERNO versus First Rand Bank Limited, 2012, JDR 0564, Western Cape. And in that judgment by the Honorable Glolo J, reliance was placed on the two South African Supreme Court of Appeal judgments, the well-known Thorpe and others versus Trittenbein, 2007, 2 SA 172 SCA, in which case the number of trustees fell below the minimum, and the court found that whatever the remaining trustees did amounted to a nullity and could not be ratified. And the matter Absa Bank Limited versus Sakavu National Provident Fund under curatorship, 2012, 1 All South Africa 121 SCA, in which case the National Provident Fund constitution was not complied with. And the court found that whatever the remaining trustees did was a nullity and could not be ratified. Court relied on the judgment of the Witwatersrand High Court, or approved the judgment of the Witwatersrand High Court in Grundling versus Beyers and others, in square paragraph 37 of the Sakavu judgment, in which it was said, referring to a union, the former are the union's powers, the latter its internal management. If it exceeds the former powers, that is, does an act that the Constitution does not require or permit it to do, that act is ultra vires and null and void. Such an act cannot be validated by ratification or estoppel, and the union, any outsider affected by it, or a member may, if necessary, have it set aside or declared null and void. I submit that is the position with the ninth appellant. The litigation respect of the ninth appellant has shown that the dissatisfied parties will not hesitate to litigate. In the relevant period, 2016-2017, besides this application, there was another application for the setting aside, the one that the minister conceded the merits of. And I submit the 9th appellant is at risk should the appointment be set aside, that many of the decisions, or the invalid decisions, could be revisited and it could become a quagmire. And although that could have been addressed in the papers, should have been addressed in the papers, what the parties, the appellants should have done is simply say, well, we have passed resolution A, B, and C, and we have concluded contracts A, B, and C. I submit, my lords, that can be accepted for a period of 21 months up to now, up to the judgment of the court quo. They didn't do nothing. There must be consequences, severe consequences, not only for the 9th appellant, but also for third parties who are involved in or affected by these decisions. I submit, if one compares that prejudice to any possible prejudice the respondents in this matter could possibly have suffered, and none is disclosed, I submit the court quo should not have set aside the appointment. And this court is asked to reverse only the setting aside. Your lordships will see we filed a proposed order. We do not seek an order of costs in the court quo or in this court. We simply want position of the 9th respondent safeguarded or possible consequences prevented.
Well, shouldn't the respondents be entitled to their costs in the court quo? They would have been substantially successful.
Yes, my lords. Yes, actually they should be liable for the costs, because in the court quo, the finding of invalidity is success. Yes, my lord. That would be the proper order.
Well, I have one final question. I just do not understand why these issues were not set out by your client because we have to speculate what kind of decisions were made and that sort of thing. This is the type of prejudice that should be set aside factually before a court, so that the respondents could have dealt with it at the time of the proceedings in reply, and the court would have then had the benefit of a proper factual basis instead of speculative submissions that you're making.
Yes, my lord. My lord, with respect, I submit there must be prejudice. Although the facts aren't stated, there must be prejudice. There must have been interaction with third parties on high level, keeping in mind the business of Meatco. And I submit with respect that it can be accepted that there will be adverse consequences. The fact that it wasn't pertinently addressed in the papers, my lords, is unfortunate. On the other hand, what would the respondents have replied in the court quo? That there wasn't anything? I submit that they could never have done. And, my lords, I am not sure from reading the authorities on who the onus rests to establish a case for the default remedy of setting aside, whether it is the applicants or whether it is the respondents that must make out a case for the default remedy of setting aside. Be that as it may, I submit in this case, it can be assumed, and the court is respectfully requested to accept that there would be adverse consequences for the 9th appellant, and that will be no consequences should it not be set aside for the respondents in this matter. No consequences whatsoever.
Thank you.
Yes, counsel, I want to be clear. Which grounds do you abandon and which ones don't you?
I abandon the second ground, the Functus Officio ground, my lord.
But you must surely abandon all your other grounds directed at invalidity, because once if it's invalid for that reason, the others fall away.
Yes, they do fall away.
So you're not attacking the court's finding about the invalidity of the appointment.
Although the first appellant was aggrieved at the time with the judgment, it will serve nothing to vindicate his feelings. Because if I concede the second round of appeal, what we should rely on is, it remains only to rely on the sixth round of appeal.
Okay, so you mentioned the second. Take me through the list, please.
The first is the ultra vires finding that, and I submit, that is, the argument starts on page 3 of the heads of argument, my lords.
Now, the first ground you don't abandon. I want, let's have some systematic way. You don't abandon the first ground.
No, I abandon the second ground, the Functus Officio ground.
Yeah, but the first ground you don't abandon.
I don't know, no. But it becomes academic if I abandon the second ground. Because I then admit the invalidity and it does not serve any. If I abandon the second ground and I concede that the first appellant was Functus Officio when it did this appointment, it matters not whether I succeed with the first, the third, fourth, or fifth grounds, my lords, because I would have conceded invalidity.
So you mentioned the fifth ground, unreasonable delay. That's yes. Also falls away, you say.
If I no, I beg your pardon, your lordship is of course correct. That is not affected by the concession on the second ground. The fifth ground is the ground of the delay. And I stand corrected, your lordship, of course, even though I concede ground 2 and thereby concede that the appointment was of invalidity, it doesn't affect the fifth ground of the appeal, the delay. For if the court finds that the delay was such that it cannot be condoned, then it matters not whether there was invalidity, and then the sixth ground of appeal is also not necessary.
No, but you got to just wait a minute there. That can't be correct. On the basis of the South African poultry case, it's not just simply a question of considering the delay. The second component, and there was an application for condonation, is considering the interests of justice. And when you consider the interests of justice, you have to consider the merits, and you have conceded the merits. What you have done by conceding ground 2, which I think is a correct concession, counsel. I'm not arguing with you. I'm just saying that once you concede the merits, you can have very little basis to complain about the delay point, can you? When there's an application for condonation, because the merits is a central component of the consideration of condonation in the context of the delay rule.
Yes, my lord. My lord, when considering...
Naturally, we will also have to look at what the prejudice is overall. In considering yes. What the unreasonable delay is, prejudice overall is an irrelevant consideration.
Yes, ma'am. I submit it is not, although the merits is a factor, also the explanation for the delay is important. And if a delay is so bad that irrespective of good merits, a court will not condone. And in this case, my lord, the conceded action, the conceded invalidity was simply that the minister acted too quickly.
Appear to me the prejudice would lie in the overall interest of the good administration. I mean, if a decision such as that is set aside and the prejudice is not unrelated to the question you made about the consequences to the ninth respondent.
The two issues are related now. If in the 6.5 month period of the delay, and keeping in mind it would still take a further period for the judgment to be delivered, I submit this was a case where interim relief was indicated. And added to that, the explanation given by the respondents for the delay was pointed out in the reply not to be truthful. They attempted to mislead the court quo. I submit that also plays a factor in the decision to condone the delay or not to condone the delay.
Yes, I'm not sure if there is anything further.
Not from my side, thank you, Deputy Chief Justice.
Thank you, Justice Mats. Judge Hoff, anything? You must unmute. You must.
Okay, just want to clarify something in the heads to the effect that since there has been a new board been appointed, that the whole appeal has become academic.
Yes, ma'am. It has
So
become
that
academic.
Irrespective of the order that this court may or may not give, it will have no practical effect according to that submission.
For the respondents, my lord.
Yes.
For the respondents only, but not for the applicants, for the especially the ninth appellant. It will have far-reaching consequences. It is not academic as far as the ninth appellant and the other appellants are concerned. It has become academic as far as the respondents are concerned.
Yes. Yes, thank you.
I assume whichever way it goes in your favor, cost you don't insist on. If it goes in your favor, whether it's on any of the grounds that you rely on.
My lords, my instructions are not to seek an order for costs.
Okay.
In this court and to concede the costs in the court quo.
My brothers, anything further?
No, thank you, Deputy Chief Justice.
So thank you.
Unless there is something you want to add, Counsel, we seem to have reached the end of the discussion.
Thank you, my lords. That is my argument.
Thank you very much. Well, what's left of me is on behalf of my colleagues to thank you for your submissions, both written and oral, and judgment is reserved.
My lord.
We will terminate the session. Judge Hoff, when are you back in chambers?
He's back in chambers on